So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write,
Or
whether reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if, for the purposes of legislative competence, appeal is a part of procedural law, if that is so, then Parliament can also confer appeal.
Not all appeals, but intra-quota.
Intra-quota. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184(3) are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous power exercise.
This Order 5 Rule 2 that you read, even though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the party.
Yes, yes.
And the rules are providing for that appeal.
Yes, yes. So this is one way I can add that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes, yes.
Okay.
Yes.
And why
They
did-
are not always restrictive, my
If
lord.
I may follow what my learned colleague has said with regard to Order 5, why didn't
I can't
they
hear
use the
you.
word-
I can't hear you. I mean, I can't hear you.
I'm so sorry. What my learned colleague said regarding Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So this
If
is a
an
review?
appeal, This is not a review.
Reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
A review, practice and procedure में review का power confer कर दिया.
ये देखिए ना जी.
अगर
deliberately
in an appeal, can't a judge who passed an order sit?
Sir, that is not the notion of how things are.
I suppose he's one judge. I
Sir,
don't know.
अगर
For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is, because one set of arguments were, the third judge hasn't heard the arguments as well, or that particular question as articulated was not put to them.
Yes, yes.
So can the Chief Justice then say, can you all three sit together and decide it? Since now the possibility of a hung court will not arise. It can still go in 3 different ways. So what is that called? I mean, that option is available to the Chief Justice. I'm adding another member on the bench and hear this matter again. Or whatever you want to call it.
And if I could add to that, if you look at Section 5, you see, I mean, this is a traditional notion, but if you look at Section 5 of the law, the one under challenge,
Yes,
it says that the appeal will go to a larger bench. Now, I just want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? I mean, traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't 1 or 2 other judges be added to it? I mean, is there a problem somewhere, or does it?
My lord,
is there
For instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and one judge has been removed, 3 have been added. So that judge here, himself being bench, is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as His Lordship, Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your Lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal. You should kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this
There
word
are
reconsideration.
two parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is
against
against
the order of the registrar in
But
chamber.
that is
And
against
suppose if we
registrar.
were to consider section 5
That
and
is why
consider it as
the
a
word-
reconsideration,
That is why the word reconsideration has been used,
Has-
in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it's
Yes,
not just like
yes.
an appeal.
But let us
See,
and if we were to just say that section 5 is a reconsideration, and
Sir,
let's not in the word
let's
appeal,
let's
could it
just
not
focus
be
on
passed
this
the
word
muster?
reconsideration. What is happening? Sir, मैं एक बात
That is why
मैं
the
एक बात
judge answered, it is not an appeal, reconsideration.
लेकिन ये आप
इसलिए बैठ
देखिए, ये
सकते
जो
हो।
रिव्यू एक्ट जो पास हुआ था, इस एक्ट के बाद उसमें लिखा गया था रिव्यू शैल बी हर्ड लाइक
जी,
एन
मैं उस पे भी आ रहा था
and उसके अंदर speaking entirely for myself,
And it was struck down on
I have given a concurring judgment in which I have pointed out the serious jurisprudential issues that would arise where half the bench is essentially hearing it as a because they've heard it before as review, and half the bench is hearing it for the first time, therefore an appeal. You can't mix and match like that.
Sir, let's forget about this distinction between appeal and
Constitution की वजह तो Constitution का
No,
distinction ही खत्म हो जाती है.
let us concentrate about the word reconsideration. Single judge ने order किया है, उसको reconsider कर रहे हैं 3 judges.
But that is on the administrative side, it's not
Sir,
the judicial
उसमें
order.
applications
Right.
decide हो रही हैं. अब reconsideration has become, which is in the nature
But
of a review.
all those matters in order 5, even though, well, it passes for whatever we may call it as an administrative, but there's substantive rights being decided.
And they have been made a part of a law which is limited to practice and procedure.
But
So the
Parliament
word
is-
Is
reconsideration.
it
Parliament
on
has called it an
administrative
appeal.
side, Mr. Faisal, or the judicial side?
Ji sir,
Is this on the administrative side or the judicial side?
this is on the administrative side, sir.
Then why the word use aggrieved party by a bench of not less than 3 members? The bench is constituted.
Yeah, I don't know
The
if this
judicial
is.
side or the administrative side?
Taking that point further, I mean, whether at all these straight jackets about this administrative moving into judicial,
The
moving
point
into
is-
Probably the bard said it best. A rose by name would smell just as sweet.
I would
So
say-
whatever you call it,
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appeals as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175.2, the judgment authored by her ladyship Aisha Malik Sahiba has also relied on 175.2, read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court.